Yes, Mr. McAnally.
Thank you, my Lord. So I just started on a journey through the trust deed just before we took the break, and I've already touched briefly on clause 14 as dealt with in the written case. I'm not going to spend time labouring that any further. What I will do, though, because they appear adjacent to one another, is take the board to clause 13, which my Lord touched upon just before the break. And the Court of Appeal regarded clause 13 as not as important as clause 14, but important from an interpretation point of view. My submission is that clause 13 doesn't enable the deed to be interpreted in a way that requires an interpretation or construction that is beyond common sense or inconsistent with the context in which the document was made. And in any case, the purpose of clause 13 is evident from its own terms, and it starts by referring to recognition of the exigencies and risks of proceeding with the acquisition, maintenance, management and disposal of businesses and property, which I take to be a reference to the commercial nature or intentions for, at the very least, the Arangi Trust and probably the Webb family trust as well. And we get into the substance of it, and we come to 13.1a, and the clause invites the most liberal and least restrictive interpretation of these powers conferred by law, and then concludes the extent of the powers the most liberal and least restrictive interpretation of these powers conferred by law shall be applied in determining the extent of the powers, discretions and authorities of the trustee. What I submit that pertains to is what the trust may do. It doesn't pertain to how the trust might do it. If the trustees, for argument's sake, view it as appropriate to acquire a commercial property, then the deed should be interpreted accordingly. If the trustees wish to dispose of a commercial property, the same follows. Clause 13.1a in my submission is more concerned with what the trustees may do in terms of the commercial activities undertaken by it. And some support is obtained from 13.1b, which says the trustee may proceed with the least restraint appropriate, and that's an important word because it's not an unfettered discretion or right to manage. The least restraint appropriate in the management and conduct of the affairs of the trust, and in the manner most approximate to that of a sui juris individual dealing with his own property in a prudent manner. And what 13.1b is designed to do, and does do in conjunction with 13.1c, is allow the trustees to deal, particularly in relation to the trust's commercial affairs, other than as a prudent person managing the affairs of others. And that is the reference to sections 13b, 13c and 13d of the Trustee Act in 13.1c. I'm sorry, my lords, my lady, those sections aren't in the bundle, but what 13b and 13c effectively do is require trustees to exercise the prudence of a person managing or conducting the affairs of others. 13d says that obligation applies unless a contrary intention appears, and 13.1c of our trust deed says, well, this is a contrary intention. You can manage the trust's affairs as a person dealing with your own property. So it is a lower standard. It enables the trust to effectively carry out business as if it were a commercial entity doing as much, but it doesn't. Let me back up. What it does, it is consistent with the commercial purposes that were contemplated at the time that the trust was incorporated. It is not some sinister provision which says you can interpret the provisions of this trust deed by which you are governed as trustees in any way you like. It doesn't say that. It is simply a benchmark against which matters such as prudent investment are measured. And clause 14, it may well be no accident that it follows, because it also deals, in my submission, with the execution of commercial matters and does enable a certain amount of latitude in terms of dealing with third parties with which a trustee may have an interest, and that upon a strict application of the laws of equity might preclude the trust entering into a certain transaction. It doesn't, in my submission, allow trustees, as the Court of Appeal seem to hold, to breach their fiduciary obligations. There may well be an apparent or a potential conflict in a certain transaction. The trustees may still regard that transaction as in the best interests of the trust because this clause allows them to do so. What it doesn't allow them to do is to carry on with a transaction that is not consistent with their fiduciary obligations. And those are probably the key provisions in terms of the trustees' powers and discretions in the substantive part of the trust deed. I skip over a couple of pages to the schedule, and in particular clauses 1.1 and 2.1 that my Lord Wilson mentioned before lunch. Clause 1.1 is indeed wide-ranging in the sense that it does enable trustees to make distributions or applications of income and capital to one beneficiary and not another or others. And it is ultimately for the trustees to make those decisions, as one would expect, but there is a measure of propriety provided for in the clause itself, the relevant part of which says trustees may make distributions and so forth to one or more to the beneficiaries, one or more to the exclusion of the other or others as a trustee in a sole uncontrolled discretion. And if the provision ended there, then there may well be some problems, but it doesn't. As a trustee in a sole uncontrolled discretion shall think proper. And that, in my submission, is the objective aspect of that, objective part of that clause. Because a trustee who acts in his sole uncontrolled discretion without turning his mind, or her mind as the case might be, to what is proper, is in breach. And what is proper lends itself to a degree of objective analysis. And I draw or make the analogy with the duty to act honestly, and in what the company director or the trustee, as the case may be, believes to be in the best interests of the company or the beneficiary, as the case might be. It is a subjective analysis. As long as the trustee is acting honestly, then prima facie at least, he or she has acted in accordance with her obligations. But if he has misdirected himself in terms of what the appropriate, what is in the best interests of the subject party, then he has not acted in accordance with that obligation. The case in New Zealand, which I recall, is Sojourner and Robb, where I'll come back to the name in a moment, my Lord, but the situation there was the company directors believed it was in the interests of the shareholders, who happened to be themselves, to strip the company of its assets. The company at that time was insolvent, and unsurprisingly, the courts in New Zealand held that, well, when you are when you are a company director, in a situation of insolvency, your duty to the company includes an obligation to take into account the interests of creditors. You didn't do that, therefore, whilst you may have been honestly acting on what you believed to be in the best interest of the company, you had effectively misdirected yourself. And I would say the same would apply here. If a trustee failed to direct his or her mind to what is proper and have objectively identifiable reasons for concluding that a distribution was proper, then the clause would come into play. The case I was referring to, my lord, my lady, if it is relevant, is Sojourner, S-O-J-O-U-R-N-E-R, and Rob, but I can't give you a citation at this point, but could do so at a later date if needed. Or I'm emailing
If we want to look at it, we'll ask for your further help.
Thank you. It's helpful.
At the moment, we don't.
Thank you. And that brings me to clause 2.1. I'm not sure clause 2.1 was of concern. No, I won't, unless my lords or my lady have a concern around 2.1, I won't deal with that because it looks relatively.
Is this the final distribution of the capital at the end of the trust period?
Yes, it does deal with
I see. Well, I think the powers there are already really covered for our purposes in one. And then, of course, I think I did refer you to the power of the trustee to vary the terms. But,
yes.
Well, you've got to decide how much further you want to go in all this.
Well, I will deal with that particular power, my lord, and the powers and the trustees generally, and I can probably wrap them up in this way, in that if the board accepts that those clauses that I've just referred the board to aren't as wide as the Court of Appeal was inclined to hold, and do have within them and in their context the restraints or fetters that I've just submitted, then the powers of the trustees, whatever they might be, are of course fiduciary powers, and however they're exercised, must be in accordance with those fiduciary obligations. So the power of amendment that my Lord Wilson has just referred to, the power of resettlement, are all fiduciary powers and must be exercised accordingly. So they cannot be taken to in some way contradict or invalidate the existence of these trusts. They are simply powers for trustees to exercise in accordance with their fiduciary obligations as such.
Having in mind that the husband is the settlor and one of the beneficiaries of this trust at inception, can he, under clause 10.1, simply, as it were, remove his son, leave himself as the sole beneficiary, or replace him and his son with himself as a sole beneficiary, and if not, why not?
This particular clause in my submission is the important one. For the reasons largely just articulated, nothing in my submission turns upon the trustees' powers. Similarly, the consultants' powers are limited in my submission, and they are traversed in the written case. But this is the interesting one because this is a settlor power, and of course that creates problems in itself in that they are not necessarily fiduciary. I submit.
Well, it's hard to see how a general power to replace one set of beneficiaries with another by a nomination could be fiduciary.
It's a difficult point, my lord, and probably the one where I have the most work to do. I submit that whether or not it is a power that can be putting aside whether we call it a fiduciary power or otherwise, but I submit it's a matter of interpretation as to whether or not the trustees contemplate that power and therefore permit that power being exercised in that way. And if it doesn't, then a selfish exercise by Mr. Webb, as my lord has alluded to, could well be a fraud on a power. And I mean, an excess of...
How does one ascertain what the purpose of this power is, other than to give the settlor an unrestricted power to direct who from time to time should be the beneficial owner of the trust property?
Well, the question I perhaps put it thus, my lord, and that is, what was the intended purpose
Yes.
of the power, and I refer to the context where, particularly in the case of the Arangi Trust, where Mr. Webb had a child from a previous marriage, but he was entering into a new marriage, I should say, and so more children would be in contemplation. There was at the same time the planned acquisition of the property at Arangi, and I submit that the purpose of the power was to enable the trust to adapt to changed circumstances, such as bringing in, as subsequently did happen, the daughter of the later marriage to Mrs. Webb. That wouldn't necessarily contemplate the removal of Sebastian Webb, who is the son from the first marriage, and that hasn't happened.
Well, Clause 10 appears under a heading, nomination and removal. It's fair to say there isn't any language, I think, about removal in the text of Clause 10, but a nomination of beneficiaries which simply replaced another nomination would effectively remove any existing beneficiary not named in the new nomination.
I have to accept that, my lord, but submit that the absence of any express power of removal as distinct from this power of replacement in itself is telling. If it was intended that he might simply remove, for example, Sebastian as a beneficiary in favour of making himself sole beneficiary, the clause could have just said so. So it is a matter of interpretation. I rely upon context, the wording. In the Court of Appeal, I did argue that, as my Lord Briggs has just alluded to, that a replacement requires a replacement. It doesn't allow a reduction in the number of beneficiaries. I don't necessarily...
Why couldn't you have 10 beneficiaries on a Tuesday and a nomination form naming 5 on a Wednesday?
I have to accept, my Lord, that is a possibility on the wording of the clause, but it doesn't expressly say that. It does contemplate replacement, by replacement, rather than straight removal. So it may be said to strain the wording of the clause to say that that the making Paul Webb the sole beneficiary rather than Sebastian Webb and Paul Webb the beneficiaries is a replacement and not simply a removal, which the clause does not seem to contemplate. It contemplates removal only by replacement. If I were relying solely upon the words of the clause, I might be more brave than I perhaps am in advancing that submission, but I do rely upon the context as well, where Mr. Webb's family situation at that time was fluid. His business interests were potentially fluid in terms of a new acquisition in the Cook Islands and his ongoing involvement with a wider business group. And so in that context, I submit that however one ultimately construes it in terms of what is possible, what I submit the clause does not contemplate is Mr. Webb making himself sole beneficiary. and that is either by approaching or the power as a fiduciary one. In the written case, I rely on the decision of the Supreme Court of New Zealand in Churnside, I should say, and Fay, where the Supreme Court identified those two categories of fiduciary relationships, those that are inherently fiduciary and those that, because of the particular circumstances, impose fiduciary obligations. And that was a joint venture case, and in that particular instance, the joint venture was held to because a company structure was used, the joint venture was not inherently fiduciary, but there were aspects of it, because of the way the business was structured, that made aspects of it fiduciary. And so,
Can you speak up a bit? We can hear you, but I'm not sure people can necessarily hear you.
sorry, my Lord.
Thank you.
So either viewing it as a fiduciary relationship because of the circumstances and the context, or as simply as a power which has limitations on it, then excess of it would be a fraud on that power in my submission. Now, as I must accept, that is the most difficult clause for Mr. Webb. I would like to think that it can be dealt with as I submit. Even if it can't, it doesn't invalidate the trust itself, and that perhaps brings me to the wider issue in terms of what is the effect of these clauses, depending on what view the board ultimately takes of them. And the Court of Appeal, of course, held that they invalidated the trusts because there wasn't a sufficient alienation of the trust property. Probably the only other case which really gets to that point is the Pugachev one, which I've mentioned earlier, and which the board is probably familiar with. And in that case, whilst Mr. Justice Burse did ultimately find that the trusts in that case were shams, he also found that the extent of the control Mr. Pugachev retained over the trust assets was such that there was no effective alienation of the trust property. His Lordship relied upon both the Clayton decision from the Supreme Court of New Zealand and also upon this board's advice in, it's a case I didn't want to mention because its name is horrible, so I will just refer to it as the Whonu and Merrill Lynch case, but of course its full name is Tasarruf Mev Duarte Segota Whonu and Merrill Lynch Bank and Trust Co. Cayman Limited and others, often referred to as TMSF. And the board might be aware that case concerned a trust that included a power of revocation vested in the settlor. And the settlor, of course, was insolvent, and the question was whether that power was available to his receivers. And of course, it was the power to revoke, whilst it had not been exercised, was regarded as property. And the advice to Her Majesty was that in order to be made, that the power of revocation be delegated to the receivers so it might be exercised, and the trust revoked and the assets used to pay creditors. It was not suggested in that case that the trust itself was in some way invalid, or that the assets themselves were available prior to revocation to the receivers. Similarly, in the Clayton case from the Supreme Court of New Zealand, it was held that there was ultimately a power similar to that which is alleged Mr. Webb has here, whereby the settlor as principal family member could make himself sole beneficiary and distribute the trust assets to himself. That power was regarded by the Supreme Court as being property for the purposes of the relationship property regime, and to be valued and put into the mix in terms of the division. The Supreme Court didn't take the view that such an order made the trust assets themselves available to the other party. In that case, the point was left as a live one. The court didn't have to determine whether such powers could in fact have the effect of invalidating the trust. It observed two possible outcomes, the other being, which I submit, is that which was reached in the board's advice in TMSF, was that if there is such a power, and if I were wrong and the board were of the view that clause 10.1 of this trust deed is tantamount to a power of revocation, then that doesn't invalidate the trusts. It just means there is a power that might have some value in the hands of Mr. Webb until such time as it is exercised. And let's bear in mind that the Arangi Trust in particular has now been in place for some 14 years, and no such power has been exercised. Until such time as the power is exercised, the trust subsists, and the beneficiaries have the rights inherent in that trust structure.
But if it isn't a fiduciary power, and it's like the power of revocation in the Merrill Lynch case, is there any principal basis upon which the court could or would have to decline to direct the husband as to the exercise of that power in much the same way as in Merrill Lynch it did it by way of delegation? The court could start, I mean, I'm putting to you to see what your answer is, not because I'm saying it's right, but the court could take a two-stage approach. It could value that power, possibly the full value of the trust property, if it included a power to leave the husband as the sole beneficiary by then direct either that he exercise that power or, I suppose, give it to the wife to exercise that power as his delegate.
The latter would be the only possibility that I think of, my Lord. But
why couldn't it direct, if it's a beneficial power rather than a fiduciary power, why couldn't the court simply direct him to exercise it in that way by revoking, by a new nomination of himself as the sole beneficiary? He could then presumably collapse the trust under Saunders and Berthier, and it could be transferred.
my answer, my Lord, I think is that the constraint is probably in terms of what the court can do under the Matrimonial Property
Yes,
Act.
absolutely, yes. That's where I was seeking your assistance. I mean, suppose a husband held property under a bare trust. I'm sorry, he wasn't the trustee. Suppose the property was held for a husband under a bare trust. The court decided that the property should be transferred to the wife. How would it, in the ordinary course of events in New Zealand or the Cook Islands, be achieved by the court? How would it? Could it?
Sorry, my Lord, I'm taking more time than I'd like to.
Surely in the Clayton case, Mr. McAnally, all this was short-circuited. We've got the Clayton case, haven't we, at E, in the primary bundle of authorities, and it would start at 102, forgive me, it would start at 1030, and it's a long, important judgment from your Supreme Court. But if we go to the actual order at the end, which is at 1064, we see the orders up the top of the page, and we see Order C, which was we substitute a finding that the powers of Mr. Clayton as principal family member and trustee under these various clauses of the family trust are property and relationship property having a value equal to that of the net assets of the trust. And so they short-circuit exercise of powers and simply say, there are all these powers here. We treat him as having assets to the value of the trust over which he has all these powers. And as I read the Court of Appeal in the present case, that was a line, possibly an alternative line, that they took. And it's your task to persuade us that they weren't entitled to do so.
Yes, well, that is essentially my point. The trust is left intact, and there may, of course, this is all subject to the enforceability, the debt issue and so forth, because if Section 25 applies, then none of this arises in any case. But if it does, and I'm wrong on Clause 10.1, then the expected outcome or usual outcome would be what occurred in Clayton, where we have a valuation issue. It may not be terribly difficult. One of the things that is largely agreed in this case, of course, has been valuations of a number of the assets, and one asset upon which value has been agreed is the Ararangi property.
My question, that's the valuation stage, but the court still has to get the property out of the trust into the hands of the wife to complete the exercise.
What about Section 33(3)(m) of what is transported into Cook Island law, I think, from the New Zealand provisions, which is that the court may make an order varying the terms of any trust. 33(3)(m).
Do you have a page?
1286 in the printed, so add 11.
7.
I've only just happened on it, so I certainly haven't followed it through.
That, as best I can do to assist the board as far as that goes, is to say that would apply in the case where there is an interest in a trust which is matrimonial property. And the best example I can think of is the case where a party is a final beneficiary. And it may well be that, for example, if a spouse is the only final beneficiary of a trust, then the vesting date, for argument's sake, might be changed. But I doubt very much, and can't put it much higher than that clause, that particular paragraph would enable a court to vary the terms of a trust.
Well, if there was only one effective beneficiary in the trust, because they could nominate themselves, or whichever route they chose to do it, because there's certainly provision for payment of money from one to another, isn't there? So genuine trust, but he's able to arrive at a situation in which he gets all the money.
But the distinction here, I suppose, and it's a matter of jurisdiction ultimately, is that the matrimonial property, if there is any, is not an interest in the trust, because it is a discretionary trust. So even as final beneficiary, Mr. Webb only has an expectancy, which isn't sufficient property for these purposes. What we have is a power that is something different again. So my submission, my lady, is that subclause just doesn't apply in this case. And I still haven't an answer for my Lord Briggs's question, I'm sorry.
Well, don't worry about it. We're-
Let me come back to it, my Lord, if I may.
Yes.
The handicap I have is that I am, as I suspect my learned friends are more used to the 2001 New Zealand legislation, which is structured slightly differently. There are some common aspects, but the section I expect to find where I would normally find it isn't where I expected it to be. So coming back to my main point, it is a matter of interpretation in terms of whether or not that particular power can be exercised selfishly, and I submit not. So that really takes me through the trust deed. There are arguments in the written cases around the role of consultant and the powers attaching to that. The main difference, although it may not actually matter in the end result, is whether or not the trustee and the consultant can be the same person. I say not, notwithstanding the fact that Mr. Webb purported to appoint himself consultant, and I say that in very abbreviated terms, is because the consultant may be appointed by the trustee to advise the latter, and there is a certain nonsense if one is appointing one to advise oneself. And I'll just refer to this part of clause 5.1, which deals with the appointment to illustrate my point. And it says, to assist the trustee in the administration and management of the trustee may appoint by letter of appointment a consultant. So the trust, if I am wrong, then the trustee can write to himself, recording his appointment, and then he can sign his own letter from himself, signifying consent to his appointment. Ultimately, I submit it doesn't matter, because the main power, I suppose, of the consultant to which offence is taken is a power to remove and appoint trustees, and that is found in clause 6.2 of the trust deeds. And the Court of Appeal in particular was concerned that if, assuming Mr. Webb could appoint himself consultant to himself, then he could stack the trust with tame beneficiaries, and given the court's interpretation of clauses 13 and 14, tame trustees, I should say, those tame trustees could do Mr. Webb's bidding. I say that is not so, not only because clauses 13 and 14 and others aren't as sinister as they've been taken to be, but the trustees appointed still have their fiduciary obligations. And stack all he likes, if tame trustees do Mr. Webb's bidding as consultant or what have you, they are no different to any other recalcitrant trustee and can be held to account accordingly. So I submit the board does not need to spend too much time worrying about the position of consultant, nor in fact trustee, and the important clause is that 10.1, and I emphasise that needs to be dealt with in its context and addressed in its context, and it doesn't contemplate selfish exercise.
How are we getting on, Mr. McInerney?
We're getting on well, my lords.
Good.
I'm conscious that I need to give my friend some time very soon, and I will do so. The board, if it suits the board. There is, before I leave the questions of the various powers and clauses and what have you in the trust deed, and rather than leaving everything for reply, there were a couple of other matters raised in Mrs. Webb's written case, which I'll address. At paragraph 67 of that case, and I'll
No, this is the gobbledygook about the identity of the beneficiaries, isn't it?
Well, I can probably find it. Paragraph 67, we're on.
Of the wife's case.
975 of the electronic bundle.
Oh, yes.
Yes.
Now these particular, there's a list of matters there. I'm not going to go through them all in detail, but these are relied upon, as I understand it, in support of that argument that I expressed concern about at the outset, and that is that we can have provisions in a trust deed that on their face create a trust, but in some way evidence a lack of an objective intention to create a trust. And I say that goes further than the law permits, and there is a certain danger in taking that kind of view, because we cross the line from a question around certainty of intention to sham, and we merge the two, and we say, well, there's a sham because the clauses of your trust deed aren't very nice, and a person who settled a trust with these terms in it can't really can't be taken to have intended to make a trust. And that is not acceptable in my submission. There's criticism made of the fact that at the time of settlement of the Ararangi Trust, the only beneficiaries were Mr. Webb and his then 3-year-old son. But there's no prohibition, certainly that I'm aware of, about minor children being the beneficiaries of trusts. And in the facts of this particular case, apart from Mr. Webb's son and a very new wife, Mr. Webb is not known to have other family that he might otherwise have included. So whether we like it or not, and whether or not there might in fact have been some sinister motivation behind that, the reality that from an objective point of view, it's quite understandable why someone might make simply themselves and their only son the beneficiaries of a trust such as this. Whilst there is a power in the trustee to appoint a consultant, and I've already submitted why I say that it's not overly relevant, but the very power of appointment of a consultant would be fiduciary in nature anyway, being a trustee power, and given that the purpose of the consultant is to further the administration of the trust, a trustee would be expected to exercise that power and appoint someone that is consistent with the interests of the beneficiaries. And I've talked about clauses 14 and 13, and they are matters of interpretation. Now, there might be more than one possible interpretation of any clause of a trust deed. The board might ultimately find that that I am wrong and clauses 13 and 14 are in fact sinister. But that is a different matter to whether or not there was an underlying intention to create a trust, because it is reasonable people may well disagree on the interpretation of a particular clause. Now, the clauses will have an effect, but they will have an effect on whether a trust was created, not whether in fact the trust is some sort of objective sham. So unless there's anything, I still don't have that answer to my Lord Briggs's question. Perhaps that's something I can deal with in my time and reply tomorrow.
Good idea.
Kind of a proper look at the.
So now we come on to the final section.
The final substantive matter is section 44 of the Matrimonial Property Act, and that is dealt with in the written cases, and that section is concerned with dispositions of assets made in order to defeat the rights of a party. And a common situation is where matrimonial property has been transferred to a trust during the marriage, and with the intention of defeating the other party's rights. I'm not going to dwell on the section because it is dealt with in the written case. There are possible permutations here. If the Ararangi Trust is valid, then it really falls away, because the transfers or the dispositions that Mrs. Webb is predominantly concerned with are transfers of shares in companies called Solar 3000 Limited in the Cook Islands, Fleet Lease, which was a car rental company, and that may well be it from memory. It's dealt with in the cases, my lords, my lady, so I'm not going to be more precise than that. If the Ararangi Trust is valid, then the dispositions, the transfers, cannot have defeated any rights. So there is no effect, irrespective of intention, and the section doesn't apply in those circumstances. In my submission, there is no live issue around dispositions to the Ararangi Trust. My learned friend and I perhaps disagree on whether that point was in fact advanced in the High Court and the Court of Appeal. It doesn't matter, because one of the elements of Section 44 is an intention to defeat the other party's rights, and I believe I'm correct when I say that Mr. Webb was not cross-examined on that point, and that is as far as it can be taken. In any case, the dispositions we are talking about are not particularised, and I don't want to spend any more time on that particular point. So we are concerned with the Webb Family Trust alone and transfers to it. If your lordships, my lady, do find that the Ararangi Trust is invalid and there have been transfers that fall within Section 44, we possibly run into a valuation issue, and that probably brings me to the concluding part of my submissions, and that is the inference that the Court of Appeal drew in respect of the value of the shares in Solar 3000 Limited. At risk of paraphrasing, the conclusion the Court of Appeal reached was that even after excluding shares in another Cook Islands company called Kuru Investments Limited, after attributing to the shares in Solar 3000 Limited a value of $2 million, without putting a value on the total matrimonial property pool, the Court of Appeal inferred or assumed that the $2.83 million represented by the Ararangi property was less than the value of half of the matrimonial property pool. and it could safely vest that property in Mrs. Webb without eating into Mr. Webb's 50% of the pool. That entire approach, in my respectful submission, is unsound, not only because of the absence of valuation generally, but the inference and the inferred value of $2 million on the Solar 3000 limited shares is unsustainable. And whilst we could perhaps argue for a large part of the day about whether an adverse inference was justified or not, I don't want to have that argument, and I'm sure that the board doesn't either.
Well, that was going through my mind. I mean, for the local court of appeal to say, having looked at all the evidence, this is so unsatisfactory, we've simply got to take a ballpark figure. It's very difficult for us sitting here. We're not going to go through the evidence and to see precisely how unsatisfactory it was. So it's difficult, and it'll be difficult for us to depart from the Court of Appeal in that regard, wouldn't it?
It's normally, my lord, I would say yes, but I am going to submit that the inference in this case is so assailable, if I can put it that way, that the board may well find it has to do so. And the reason I say that is that it's not a case that there was no evidence of value before the court. It was unsatisfactory, but I do submit that what evidence there was made a figure of $2 million quite unsustainable, because it could not be supported by anything. And I'm conscious of taking up your lordships and my lady's time too much on this point, because it is a somewhat more mundane point when weighed against the other matters we've had to deal with. But it is, of course, a point of huge significance for Mr. Webb, because even if he is wrong on everything else, he has received a very small proportion of the matrimonial property in his view. The main piece of evidence I rely upon to submit that the inference was unsound is the projected income for the company, the Islands Company, over a 20-year period.
Right, which page, please?
Page 561 of the record, volume 3 of the hard copies. That will be page 572 of the electronic bundle.
Yes.
And this is an investor update of October 2014. And it was heavily relied upon by Mrs. Webb in both the High Court and the Court of Appeal to contend that the company was in fact worth $10 million, and that the 33% shareholding of the Webb Family Trust was therefore worth $3.33 million. So it is equally appropriate in my submission to rely upon this for all purposes. Obviously, the $10 million figure was unsustainable because it wasn't a value attributed in this document to the company, to the group of companies, I should say, but in fact a capital raising target.
Where did you get that from?
The reference there, my lord, is to page 564, and that will be page 575, the electronic version. I rely upon the projected income over 20 years on page 561 of $5.885 million. And putting aside the fact that income, and it is income as opposed to net profit, is expected to be earned over 20 years, 33% of that figure is of itself less than $2 million. Now, I am concerned to be inviting the board to start getting into that sort of minutiae, but it's an important issue, and I submit that the Court of Appeal's inference went beyond the bounds of legitimate inference, which is a logical conclusion from proven facts, into speculation, and was used, with all due respect, as something of a means to justify an end. And that inference ought, in my submission, ultimately be set aside, even though that may well lead to the rather unsatisfactory situation where valuation issues do need to be remitted, probably to the High Court. But the error, in my submission, is sufficiently serious to justify that course.
Do we assume then that you'll be able to put in rather better evidence than you did before?
If
the jury?
I'm not going to say yes to that, my Lord, with any certainty, but what it might be is that I would have the opportunity to invite the court to consider a more realistic inference from what we do have.
But you are going to tell us what the more realistic inference is.
Well, I haven't properly considered the matter, but given the time frame involved, given that we're talking an income figure rather than a profit figure, and given the shareholding is only 33%, I would submit that $1 million for the value of Solar 3000 would be pushing it.
Sorry, is that just your speculation, or do you have instructions to put that figure forward?
Oh no, I don't have any instructions, my Lord. I hadn't got that far, but I am conscious of the fact that experience suggests that a present-day figure needs to be reached, and 20 years is a significant period of time. And whilst we don't know what the likely expenses of the company are, we do have some details in a profit and loss statement. So I would say that $1 million might be a very realistic figure, and it would perhaps be very difficult for me to be troubling your lordships and my lady with this argument if a figure akin to that had been used.
What figure was used by the husband?
It was initially $30,000, my lady. He accepted under cross-examination that was wrong, and I don't recall him improving upon that. He didn't know. It was his ultimate conclusion, and that, of course, is the chain of inquiry which led to the Court of Appeal drawing an inference. So really the submission and the problem at this point is the value of the inference rather than the drawing of the inference itself, if that makes sense.
Yes.
Now, my Lord, I'm conscious it's 3 o'clock. That is my allotted time. I have one to answer from Lord Briggs, which I'll endeavour to do tomorrow. Unless there's anything else I can help with at the moment.
It seems not. We're extremely grateful to you, Mr.
Thank you, my Lord.
McNally. Thank you very much indeed. Mr. Hickaker.
Thank you, my lords, my lady. As my learned friend has outlined, 3 questions on the appeal. The debt question, the property pool question, and then the valuation question. I'll address them in that order, and I will endeavour to mainly address the matters that have been raised. There is a lot in the case that could be said about other aspects, and I'm happy to go through that with the board if that would be useful, but I'll primarily focus on responding if that would assist. So our first position goes to the debt question, and we say that the tax liability is not taken into account when assessing the matrimonial property pool. And I'll start at the same place my learned friend did, and that's with the question of whether enforceability is relevant at all. We submit it is. And I must take issue, regrettably, with the first legal proposition my friend put, and that was that the purpose of Section 20 of the Matrimonial Property Act is to ensure that creditors are not compromised. And if I may ask the board to turn to that section, which is at page, I believe, 1026 electronically and 1015 physically in the primary authorities bundle. I shall ask the board, to go back a page earlier where the section starts.
I'm so sorry, which page, which electronic page are you on?
1025, my lord.
Thank you.
Section 21A provides that secured and unsecured creditors of a spouse shall have the same rights against that spouse and against property owned by that spouse as if this act had not been passed. It refers to the same rights. So we submit that that means if a debt is unenforceable in a domestic court, in this case because of it's a foreign tax debt, but the same could apply to a statute barred debt, then a creditor would be would still have the same rights if that debt is excluded from the calculation of the pool. And that's completely in accordance with Section 21A. And that avoids the difficulty that my Lord Kitchen identified, that the end result of my learned friend's argument would be to see, in this case, the husband take an increased pool of the matrimonial assets by raising the issue of debts that are not actually enforceable. So neither the creditors are protected in this circumstance, but one party is able to get an increased bite of the pie. And we submit that that is not what the section requires, or indeed is in line with the section. So we submit that that deals with that first issue, of whether you take into account the enforceability of the debt. And we say you must do, because of the wording of Section 21A and those phrases, the same rights. We turn then to the question of the application of the principle from Government of India and Taylor. My learned friend does not take any issue with that principle. It's one of long standing. The main question is whether there is something in the special relationship between the Cook Islands and New Zealand that means that that principle should be displaced. And before I go too much further into that question, I just note the query from my Lord Carnwath that, well, have there been any tax cases where the New Zealand Inland Revenue has sought tax in the Cook Islands? And the answer from my learned friend was no, and I certainly haven't been able to find any. And your comment that, well, it's odd we're dealing with this in London. And we submit that those questions illustrate 2 points. The first is, I submit the reason there aren't any cases on it is because it's such a principle of long standing, the New Zealand Inland Revenue Department hasn't tried. And the fact that we are dealing with this in London is an indicator of the sovereignty of the Cook Islands, because this is the final court of appeal for the Cook Islands. It is not the New Zealand Supreme Court or New Zealand Court of Appeal. So the fact that we are here is another indicator of sovereignty.
And we've got no indication of what the New Zealand tax authorities' position is in this case. I mean, they're presumably aware of it, but they've not.
Well, we've been told that they're seeking to appoint a receiver over the husband's Cook Island assets. Is that right, I think?
Yes, that's what my learned friend has advised the board.
And if that's happening, it doesn't sound like it's such an obvious no-hoper that the New Zealand tax authorities wouldn't even bother to try.
Potentially not, my lord, though I don't know the basis upon which the New Zealand Tax Authority believes it can. Now,
No.
there might
And
be...
do you have any knowledge of that?
No.
So they're simply relying on what they're being told?
And nothing to do with me or my clients, my lords, my ladies. It's between the Tax Department and Mr. Webb, and as you'll have seen from the Taxation Review Authority's decision, there is a lot there are obviously a lot of proceedings on foot between those two parties regarding recovery. So, to address this argument on the special relationship, if I may, to assist, I'd like to first note that a very similar argument was rejected in the Government of India and Taylor case, and I refer there, which case is found in the primary bundle of authorities, behind tab. I'll find the tabs. My apologies, my lords, my copy doesn't have that, but electronically...
F, it could be.
F, thank you, my lord. Electronically, the case starts at 1070. The point that I would like to refer to first comes in the speech of Viscount Simons at electronically 1086 and physically 1075. Where the Lord Chancellor notes that it was urged that whatever might be the position as between this country and a foreign country, it was not the same as between different members of the British Commonwealth. And for such a distinction, His Lordship could see no authority and no reason. And the same point is made by Lord Somerville at 1094 electronically, 1083 physically, where the statement is made, some tentative suggestion was made that some different principles should apply as between members of the Commonwealth. No ground which I could follow was put forward in support. So we submit this is a refinement of that same argument that has already been rejected. The primary reason for the rule, my lordships and my ladyship, is that it is based on the sovereignty of states. And the relationship between members of the Commonwealth, in that case, doesn't undermine the sovereignty of individual states. So too we say that the special relationship between the Cook Islands does not undermine or between the Cook Islands and New Zealand, does not undermine or alter the sovereignty of the Cook Islands. The concept of shared sovereignty suggested by my learned friend is, we submit, in error and contrary to the fundamental principles that set up sovereign states. The Cook Islands is a sovereign state. Its parliament has sovereignty under the Constitution. New Zealand may not legislate for it, and the Cook Islands participates as a full member of the international community, including with respect to New Zealand. That's why we've noted the double taxation agreements and other multilateral treaties and bilateral treaties between New Zealand and the Cook Islands. If there was still some limit on Cook Islands sovereignty internationally vis-à-vis New Zealand, then you would not have such agreements entered into between the two states. They are entered into between two sovereign states recognising each other's sovereignty. The very documents that evidence the special relationship also tell against Mr. Webb's argument. And we have probably the two key documents in the bundle before the board. Now, there isn't a memorandum of understanding between the state, as far as we can tell. It's done by letters or joint declarations of principle, both of which we have. So if we may start at page 11 112 electronically, and 1101 physically, and that physical 1101 is in the primary authorities bundle.
Tab H.
And under H. Thank you. This is a joint centenary declaration of the principles of the relationship between the Cook Islands and New Zealand, entered into by the then Prime Ministers of the two countries. The preamble recalls that the Cook Islands has full and exclusive powers to make its own laws and adopt its policies, and recognises that an evolution has taken place in the constitutional relationship between the two countries and the development of a unique relationship between them. It then talks about the partnership. And I would like first to refer at page 1115 electronically, 1104 physically, to clause 4. Clause 4, subsection 1, notes that in the conduct of its foreign affairs, the Cook Islands interacts with the international community as a sovereign and independent state. And then this particular relationship with regard to foreign affairs is addressed at 2. Any action taken by New Zealand in respect of its constitutional responsibilities for the foreign affairs of the Cook Islands will be taken on the delegated authority and as an agent or facilitator at the specific request of the Cook Islands. Section 5 of the Cook Islands Constitution Act 1964, the New Zealand legislation, thus records a responsibility to assist the Cook Islands and not a qualification of Cook Islands statehood. So an affirmation of the sovereignty and statehood, and that the special relationship does not act as a qualification. And the same point is made over the page at 1116 electronically and 1105 physically with regard to defence and security under clause 7, part 1. Basically the same words are used. It is a qualification of Cook Islands statehood. To go earlier, we can look at the exchange of letters in 1973 between the then Premier of the Cook Islands and the then Prime Minister of New Zealand, and that is found at 1888 electronically and 1877 physically, and that is in physically the Second Authorities volume 3. Volume 3 of the Secondary Authorities.
What was the number again?
1877, my Lord.
Thank you.
And the point I would highlight from that exchange, from this first letter from the Prime Minister of New Zealand to the Premier of the Cook Islands, is at page 1878, physically 1889, electronically. The second to last paragraph notes that it is therefore unusual for a state to extend its citizenship to people living in areas beyond the reach of its own laws. A recognition that New Zealand laws, which we submit must include revenue laws, does not reach the physical territory of the Cook Islands. The effect of my learned friend's argument would be to put some kind of qualification on the sovereignty of the Cook Islands vis-à-vis New Zealand, because it would be saying that a principle that applies between sovereign states does not apply between these two states. And we submit there is no basis for that. It would be a great surprise, I submit, if the Cook Islands were to find by decision of this board that it didn't actually have full sovereignty. It'd be a surprise to the Cook Islands and a surprise to the New Zealand and a surprise to the international community. One queries how such would be viewed by the United Nations Devolution from Colonisation Committee. But we submit there is no need to make that finding because that finding would be an error of law. To address my learned friend's three key arguments, I'll start with the Trans-Tasman Proceeding Act, which the Lordships were handed. I don't know how far this really gets us. What I say that it illustrates is the exact thing you would expect if a foreign revenue law was to be enforced in a country. It is an act of the New Zealand Parliament. There is an equivalent act passed in Australia, and we know that by section 3, subsection 2, which refers to the implementation in Australian law. And it is based upon a treaty. I believe it's the Trans-Tasman Agreement is the name of the treaty. We see that at section 3, subsection 1C, merely. And the agreement is Schedule 1 to the Act. We don't have any equivalent to this between the Cook Islands and New Zealand. and just a note about that. The relationship between New Zealand and Australia, if we were going to talk about this historical evolution, there has been a historical evolution in the relationship between those two states. There is, of course, provision under the Australian Constitution for New Zealand to become the seventh state of Australia, should it so wish. It's shown no inclination to do so. And that stems from the fact that historically, New Zealand was part of the colony of New South Wales by virtue of a declaration made by the then Lieutenant Governor of New South Wales on 14 January 1840. And that, in case your lordships are wondering, is why the date the common law of Great Britain applies in the Cook Islands is 14 January 1840. It's because that is the date of the proclamation from New South Wales that said any territory gained by Governor Hobson, soon to be Governor Hobson, as he went forth to begin the signing of the Treaty of Waitangi, was to be part of the colony of New South Wales. And then the shift from New Zealand to become its own colony happened on, I believe, the 3rd of May 1841, and the Cook Islands then became part of the colony of New Zealand, before itself becoming independent in 1965. My learned friend then submitted that he would have expected Section 142 of the Cook Islands Act to have changed if a rule of exclusion, as he put it, was to apply. And we submit that that's not the case, because no legislation is needed to depart from a position where a state becomes sovereign. My learned friend referred to people moving in and out of homes. Now, I'm not sure the analogy was apt, but I'll try a similar analogy. If I sell my house, my lord and my lady, I sell it, but I can't then go, but I didn't give you the right to live in my house, because my sale of my house to you carries with it the right to live there. Thus, as the gaining of sovereignty by a state carries with it the Government of India principle, if you will. Not your sovereignty means you don't enforce another state's revenue laws unless you choose to, and that would be done by Parliament. The final point my learned friend made was about the what the High Court he referred to as the gateway provision, and my Lord Briggs referred to it as a window. And he said that, 2 points on that. First, he said, well, this is the leave requirement aspect, that you need leave, that orients us. My learned friend said, well, but ex parte applications are possible on that, and I submit that doesn't add anything, because in New Zealand, an obligation, as I believe the same situation is in the United Kingdom, if one makes an application ex parte, one must bring all relevant points to the attention of the court. And a relevant point, if you were seeking to enforce a liquidated sum of damages that was based on a foreign tax debt, would be that it was based on a foreign tax debt. Secondly, he suggested that when the court refers to it as a gateway, it was directed towards whether the enforcement process could follow. And I submit that surely the gateway will also keep out something that is contrary to a fundamental rule of the common law. In this case, the rule against enforcement of foreign tax obligations. So unless I can be of any further assistance to the board on that point, I think that covers...
You mean the whole debt point? The debt point?
Yes.
Yes. Assume for the moment that you're right that the debt is unenforceable. I think you submitted that by reference, that the reference to rights in section 20 is your sort of link for saying that therefore it's not to be taken into account. But am I right in thinking that all property is to be taken into account under section 20 except immovables situated outside the Cook Islands? So that would include choses in action, for example, i.e. a claim which the party to the marriage had enforceable by of debt in some foreign country.
So on the first part of my Lord Briggs's question, I think the answer is yes, all property apart from foreign immovables is taken into account. I admit to not knowing the answer to the second part of the question of whether that would include an asset that shows an action for enforcement of a debt in a foreign country. I submit the answer is likely to be one of two. One, the answer is either no, or two, and potentially more, this is probably more doctrinally clean, it could be yes, but the value must be ascribed as zero because it is unrecoverable in that
So if a husband has a portfolio of derivatives held in New Zealand, or for that matter, London or Australia or Singapore or New York, worth millions and millions and millions, that would be left out of account and valued at zero, would it, on a property adjustment with a wife in the Cook Islands?
No, my lord, I've obviously misunderstood your question.
Yes, I think maybe I have too.
Sorry, I thought
I'm talking about a foreign, that would be a chose in action.
Yes.
A foreign chose in action in the sense it would only be enforceable in some foreign country where it was enforceable.
Yes.
Rather than in New Zealand. And I thought you said, well, you would either leave it out of account or value it at zero.
Sorry, my lord. I was thinking your lordship's the second part of the question was related to some situation where enforcement was based on some kind of foreign tax principle that could be that.
No, I'm just talking about an ordinary shows in action.
No, an ordinary shows in action. Sorry, my lord. Yes, that's taken into account and divided.
At full value.
Yes, at whatever value is
So if the... But you would ignore any tax liabilities attaching to it, for example?
In the foreign state? Yes, I submit one... Well, that could potentially affect the question of how much you value it at,
yeah.
Couldn't it? Because we would then have a situation where some of the exceptions, not the direct exceptions to the foreign revenue law, but the principle of them, that if there are funds in a foreign country, a trustee can, for example, use those funds to pay that foreign debt, even though the trustee may not be
but forget
resident there.
Trusts for the moment. Just assume that the husband has a large portfolio of derivatives in, let's say, London, pregnant with an unrealised capital gain on which, for some reason or other, he'd have to pay tax in London?
Well, I submit that the value of that portfolio cannot be divorced from the tax debt, because that portfolio could not be realised in London without the payment of that debt. So there's no question there, I submit, about an attempt to enforce that tax debt within the Cook Islands. That's just a question of valuing what's the value of a London asset in London.
Well, suppose it could be realised, but you have to make a tax return, declare the gains tax about 18 months later and pay it.
My Lord, I think we are talking about valuation principles here, and I submit that's certainly my understanding of the effect of the Act, is that would be valued having regard to the obligations that would be said to attach to that piece of property in the foreign state. But I do submit we're moving away from the question in this matter, which is whether a debt that is not enforceable within the Cook Islands is taken into account in assessing division of property within the Cook Islands.
Yes.
I mean, is it, we're concerned with the construction of the term unsecured personal debts, aren't we, in paragraph 5b? And as I understand, the way you bring in section 20A is to say, well, we're talking about, although it talks about debts, we're talking about types of rights. And by implication in 20A, rights means rights which are potentially enforceable in the Cook Islands. I mean, my Lord put you were sort of leaving them out of account, but it's rather more specific than that. It's really a question of how you construe the particular terms of this section, isn't that right?
Yes, I believe so, my Lord.
Because in the simple case against you is that whatever you say about this, it's a debt owed by Mr. Webb. Yeah. There's nothing in 25A which says that debts means debts which are enforceable in any particular jurisdiction. So you have to somehow put a gloss on that by reference to 20A, is that?
That's correct, my Lord. It is a gloss on the words of the statute, but we submit it as a gloss in that reads section 21A consistently with section 25B, and also in a way that avoids the practical and real problem that my Lord Kitchen identified about this being a sidewind way of one party being able to accrue a greater share of the matrimonial property pool to themselves by seeking to throw into that pool a bunch of debts that they can't, that aren't actually recoverable. They won't have to pay.
But it isn't it isn't that they won't have to pay it, it's that they won't have to pay it through the Cook Islands courts.
Yes, well, that's probably fair. But that could arise in a number of situations. It could arise because of this jurisdictional matter, or it could arise solely within the Cook Islands.
But suppose that it wasn't a tax debt at all. It was another debt in New Zealand within the memorandum provision, memorial, whatever the word is, for the reciprocal enforcement provision. Then what?
Then I suspect that would be taken into account because there would be no rule against it. I think that must be the case.
What about the goodwill value of a foreign business being conducted by the spouse, which incurs income tax in the country where it's being carried on? Hasn't paid its income tax. Do you devalue the business by reference to the unpaid income tax, or do you just ignore the tax because it's not enforceable in the Cook Islands?
That is a question that I'm going to very much struggle to answer, my Lord, because it would...
Well, I'm deliberately trying to creep towards our present situation, because the only difference between that and our situation is that we don't really know what it was that caused the husband to incur the tax liabilities. We know he hasn't paid them, and we don't know that they're attached to any particular asset that falls on the plus side of the valuation exercise.
Well, My Lord, to go back to the first question, I think the reason I'd struggle to answer is because I don't know whether, say, for example, as New Zealand law, whether you do actually pay income tax on goodwill as a sale of business.
I mean, it needn't be New Zealand, it could be any country in the world which had a tax regime which had that consequence.
Then we submit, no, you couldn't enforce that in the Cook Islands because it would be enforcement of
But that's the starting point. My question is, why nonetheless would you leave that liability out?
Well, we would say that it is a bright line test, I think, based on that foreign revenue rule. So,
As I understand your submission, it's got two parts. You say it must require enforcement in the Cook Islands, and it must be incapable of enforcement in the Cook Islands. So if for some reason it's brought into account in the foreign country against the asset in issue, that's fine. It's because those two elements, if they're both present, would otherwise result in a substantial windfall to the other party.
yes, thank you, my Lord. I think that's actually...
As I understand your submission, that's it.
That is a much more concise and clear way of putting my submission than I did myself. Thank you.
We've got to be realistic. Surely when we look at debt in the Act, we've got to see whether it is a debt that is a real debt. Apparently in the books, we're going to be reading it overnight to ourselves, there's this case of Livingston where somebody had some tax debt and there was no prospect of enforcement against him, so it was left out of account. But here, the debt is in New Zealand, and the debtor lives in New Zealand, as does his new wife or partner, and there are proceedings being taken for enforcement of this debt in New Zealand. And when you stand back, you've read the district judge's judgment, so have we. How's this debt arisen? He was earning vast sums during the marriage, of which your client was the beneficiary. Trouble is, he wasn't paying tax on it, because it was all called loans and other obfuscations, which have not found favour with the revenue or with the New Zealand courts. So, looking at it realistically, surely this is a debt which is going to be the subject of attempted enforcement, receivership, bankruptcy, whatever, against him. And surely, looking at it from another dimension, it is matrimonial debt. It is the debt that has arisen because these two people, during these years, lived a wonderful life with a massive income on which they paid, you might like to correct me, the husband paid no tax. So this is a legacy from the marriage. And you are saying it's all for the account of the husband, and the wife should be immune from it. What do you say about that?
My Lord, your question is premised on it being a matrimonial debt. It is accepted that it is not, that it is a personal debt. It would be what we call under the New Zealand legislation a separate property debt rather than a relationship property debt. So that in New Zealand, the section has been amended so the separate property the debts don't get taken into account when you value the matrimonial property pool. So, my Lord, your question would be much more difficult for me to answer if the appellant had not accepted that this is not a debt that was used to fund the relationship.
You might add to that, it should be no more enforceable against the wife than it is against the husband.
Yes, ma'am.
Thank you. Well, now you're moving on.
I will. Thank you. The second question, that of whether the property purportedly held by the Arorangi Trust and the Webb Family Trust is able to be divided. And I will just address the way the Court of Appeal considered this. The Court of Appeal considered this from the starting point that all counsel before it agreed that the result would be the same whether one approached it in terms of trust and validity or in terms of a bundle of powers as matrimonial property. And that the recording of that agreement is at 401 electronically and 390 physically, which is in volume 2 of the record, at paragraph 17. Sorry, just before I go much further, would it assist your lordships for me to pinpoint the section of the Livingston case where the question of the matrimonial, or the Canadian debt in that case is found?
Well, I had certainly resolved to read it overnight. If you would like to refer us to it communally now, let's do so.
Of course, your lordships no doubt read it all, but if most of the cases are relevant to this question, and I do have the pinpoint citation.
AD in volume 3.
Lords.
It's 168 something.
1686.
Yes. The relevance part of that decision is on page 1689 electronically, 1678 physically. On the right-hand column, about a third of the way down, there is a heading tax liability.
Yes.
And it is that paragraph just before it moves on to the heading Scotland, which is a different matter. And you'll see that the learned High Court judge there, I believe it was Justice Summers, did make reference to the Government of India principle when he decided.
And the paragraph concludes, so while the debt exists, it can, for practical purposes, be disregarded.
Yes, ma'am.
And so we have to look at practical purposes and see whether this debt can be disregarded in the light of where the husband lives.
I submit that that was what the approach that the High Court judge in this matter took. We submit the better approach is that of the Court of Appeal, which said no, it's the Government of India principle that applies. We don't need to then go beyond that to look at where the husband lives. The enforcement of a revenue debt, we submit, should not be dependent on where one party after the marriage decides to set up their residence. So, to go, if that's...
Thank you very much indeed.
To go back then to the question of how it's held. Now, so I was at 401 electronically, 390 physically in the Court of Appeal decision. Where paragraph 55 was agreement that the result would be the same, whether approached in terms of trust and validity or in terms of a bundle of powers. And I submit that that is why the Court of Appeal's analysis of this question alternatively uses the language of intention to alienate beneficial interest, which we see, for example, at paragraphs 53 and 56 of the decision, and also the language of powers, which we see at paragraph 60 of the decision, flicked through because of the way in which the case was presented and the agreement that it didn't matter.
But the Clayton case didn't tell us actually what would happen in the end. They got to value the property by virtue of taking it broadly like that, but then there was a settlement, wasn't there?
Yes, my Lord. Clayton and Clayton settled after oral argument but before delivery of judgment in the New Zealand Supreme Court. And the Supreme Court decided, though, that it was such an important matter that they ought to issue judgment anyway. They actually issued two judgments. The one before the board is in relation to the Vaughan Road Property Trust, which involves these questions. There's also one that involves what's known as Section 182 of the Family Proceedings Act, which has its roots in one of the old Matrimonial Causes Act from the United Kingdom. It's the one that allows the court to vary any antenuptial or postnuptial settlement.
But they didn't actually tell us in Clayton what they did to put into practice what they'd decided.
That's right, my lady.
So what is it I was slightly confused by paragraph 55. I mean, the fact that the result would be the same if we had approached it in two different ways doesn't sort of help as to which is the right way to approach it. And they approach it very much in terms of trust and validity rather than as a bundle of powers, don't they?
Yes.
Which are you saying is the right way to approach it?
I will make the approach both ways. I'm going to attempt to.
Which is your preferred one?
The bundle of powers treated as matrimonial property is a cleaner way to do it because of the very broad definition of property that is present in the Act. The other way relies more on just trust law principles without necessarily having the same overlay, so it's not as clean to explain. So I will start with, there is a significant overlap between the two because both at heart require consideration of the terms of the trust deed.
Yes, but one takes it as it is at face value and says, well, the other you have to start worrying about these difficult concepts of invalidity and relationship with sham and all that.
I respectfully demur from my learned friend's suggestion that we start getting into concepts of sham. I submit that the intention to alienate beneficial interest is based on an objective reading of the deed and what the objective result of that is, and that objective reading is a way to determine certainty of intention. If objectively the...
Well, I'm sorry, I wasn't asking you to get into the sham argument. I was saying that, as I understand it, you say we don't need to go there because there's a cleaner concept of bundle of powers which gets you to the same result. Is that what you're saying?
Yes, my lord. Sorry, I was addressing the certainty of intention point. I don't see as a sham point because it's a question of whether the document itself evidences sufficient intention to create a trust. Rather than a sham point, which I understand to be that the document itself evidences that intention and does, on its terms, create a trust, but it is actually a fraud. It is actually, it was never intended to be put into effect in its terms. That's where I see that distinction, if that's helpful.
But in terms of the consequences of it, if it is that it is not in fact a trust, then the property is his, and therefore it's part of the pool and it's easy to determine how you deal with it. If in fact it is a trust but he's got a significant powers, the bundle of powers argument, then what happens as a matter of practicality? Then
As a matter of practicality, the court's powers under Section 25 and, as my ladyship identified, Section 33 come into play to work out how it is best to give effect to an order dividing the relationship, the matrimonial property. So I can address that now if you wish, or later. But
no need, but it has its attendant problems as well then, the bundle of powers argument.
Yes, but our submission on that is that the remedial powers given to the court under this Act are very, very broad and wide, and so should not act as any barrier towards affirming the order made by the Court of Appeal, which was the vesting.
The Court of Appeal order was, quote, the leasehold interest in the matrimonial home at Ararangi is vested in the appellant wife. And I had rather assumed that were this appeal to be dismissed, you would take this judgment and this order to the land registrar in the Cook Islands and say, please put in the name of the wife as the owner. And if the land registrar then said, well, that's rather complicated, because after all, we've got it owned by a trust rather than the husband, then possibly Lady Black's power. You would have to go back to court and ask the court to use Lady Black's collateral power that she located in, I think it was section 33. Might that be the practical course?
Happily, my lord, the vesting has already occurred, so now the leasehold is in Mrs. Webb's name. Yes.
I see.
So if the appeal was to be allowed, then we're going to have to do some unwinding. And so we ultimately submit that it would be a question of difficulty and of practical futility for this board to need to make orders that, if it felt appropriate, that revest the property in Mr. Webb and require him then to transfer it back to Mrs. Webb or something like that. Because the vesting has occurred, we actually submit as a matter of practicality that the board doesn't.
So how was that achieved on the ground?
In terms of the section, or in terms of what was done to transfer this over?
What was done to transfer the leasehold interest?
I need to ask my instruction solicitors. They did it, but my understanding is that the court decision and a copy of section 33(3)J, which allows for the vesting of a leasehold interest, was taken to the land registry and said,
well, presumably the Court of Appeal made an order.
Assume that too, my lord.
Which would have included a vesting order, as it has power to do under the section.
So I'm informed there is no land registrar. That was done by the Court of Appeal decision alone.
Oh, I see. Well, anyway, it's done and dusted.
Yes, and so when I come to that point, if with that greater factual background you still wish for this point to be addressed, I'm happy to do so, but it might not be necessary.
But it's common ground that if we were to dismiss the appeal, but relying on the bundle of trust powers approach, the same result would follow and we wouldn't need to do anything to upset the order.
Yes, I certainly am of that view, and given the concession in the earlier court, I imagine.
That's your understanding?
Yes.
Yes.
So I also note the other aspect that might be of some query with regard to the Court of Appeal's approach is that they did say that the Arorangi Family Trust and the Webb Family Trust stood or fell together. And again, that was on the basis of a concession to that effect recorded in the judgment. Sorry, I had it to hand.
It's 52.
52. Thank you, my lady. Yes.
All right.
Paragraph 52.
52.
Lord, on page 400.
Round up altogether.
Yeah.
389.
So the Webb Trust had an equivalent of clause 10, I think it is, of the Arorangi Trust.
It does, though there is a difference around clause 10, because clause 10 in the Webb Family Trust, because the settlor is a Mr. Allison, the clause 10 power would be held by him. So this raises a somewhat tricky position for me, whether the board wishes for me to go through and show why, notwithstanding that difference, it doesn't matter, or whether the concession having been made and relied on by the Court of Appeal, we need to go in there at all. It won't be something I get to today.
Well, then we can consider overnight whether we want that degree of education.
Thank you, my lord. I would hope it would be
Could you, when
educative.
you are doing your overnight consideration, because clause 10 strikes me as quite important, help me with the question whether the settlor's power under clause 10 can be assigned, whether it's transferable. What would happen if he was run over by a bus? Would it devolve upon his estate? Because all those might have some consequence on its value, as it seems to me.
I submit that it is a transferable and assignable power, and what I propose to do is go through the deed and highlight the clauses.
Okay. You don't have to do it now, but just so long as you do cover it.
Certainly, my Lord. I'll submit it's actually an ambulatory provision. So, because it's actually not given to him named as settlor, it is actually when Mr. Webb writes the letter to himself, he says, I can do this. Not by office of settlor, just says I, that will be retained by me. I'll address that when I go through the documents. So, if I may turn to the terms of the deed to highlight. And I will address the powers and bundle of rights analysis first, I think. Now, the copy of the deed I am using, but I'm happy to use the other one, is the one that begins at page 823 physically, which will be 834 electronically.
Well, so long as you I'm using a different version. So long as you refer to clauses, we can cope.
Thank you, Mark. So I will begin with, of course,
Are they the same?
they are, I can't recall, there are three different versions
One
of
was
the deed.
as put in before the High Court judge, and the other was as put in before the Court of Appeal, was the impression I got from the index.
Yes, so of the three, the first deed that is there was the actual one, the only one we had at trial, which doesn't include any of the schedules. Post-trial, but before judgment, my learned friend was able to acquire a copy that starts at 823 of the deed with all the provisions, and then that further copy, which has the not evidentially sound copy, and that barcode at the bottom. That barcode indicates it's come from an Inland Revenue Department investigation. TAK will stand for Takapuna, which is where one of the IRD offices is based in Auckland. Was put in before the Court of Appeal, and I regret to say I cannot remember why. The reason I was using the 824 one is, one, it is a full deed, two, it is numbered with respect to each particular clause, and three, it is in larger type than the back, so it's easier for me to read. Starting at the preamble, Mr. Webb is the settlor, and then Mr. Webb is the sole trustee. So this was never a trust where a third party settled any property onto it. All of the property has always been held by Mr. Webb. Then we turn to Clause 2, where the initial named beneficiaries are Mr. Webb and his infant son Sebastian. However, even in this clause, it is made clear that they are named only subject to their removal or replacement, and that's the wording of Clause 2. That power of removal or replacement remains with Mr. Webb personally under Clause 10.1. It is not a clause given in any office. It is a recognition that he still holds the same power to choose whom he may appoint his property to. There are then the two clauses. Please slow me down if I am moving too quickly through this, my lords, my lady. Two clauses that deal with the interpretation of the deed. First is clause 3.2a, which is in many ways a clause in standard terms, that the interpretation of this deed in cases of doubt is to favour the broadening of the powers and restricting liabilities of the trustees. However, clause 13.1a is more unusual. That is the clause that wherein Mr. Webb as settlor directs and declares that the most liberal and least restrictive interpretation of these powers conferred by law in this deed or schedule shall be applied in determining the extent of the powers, discretions and authorities of the trustees. So to touch upon my learned friend's argument that this is just a commercial aspect in nature, I respectfully submit that doesn't stand, especially when one considers that the liberal interpretation is also to refer to any discretions. The power to apply and appropriate capital and income, as found at clause 1.1 of the schedule. It is a very broad appointment power, including not just support, benefit, maintenance, education, and advancement of life, but also for the personal use of the living beneficiaries. It is expressed to be the uncontrolled discretion of the trustee, and it can be given to one only, at the exclusion of others, as the trustee in his, quote, sole uncontrolled discretion thinks fit. There's no need to preserve the income or capital of the trust. So that is a provision that would enable the trustee to devolve the entirety of the trust fund, the capital and any accrued income, onto any one beneficiary before the vesting date of the trust, should the trustee so wish. The question of conflicts is addressed at clause 14, and that includes that the trustee can exercise powers and discretions, notwithstanding that his interests or duties conflict with the duty to the fund or to any beneficiary. Now on this we say you of course get to a similar point by operation of common law that Mr. Webb could give it all to himself, because the deed itself names him as both a trustee and a beneficiary, and I'll address that in more detail later. Then there is this role of the consultant set out throughout the deed, appointed by the trustee under clause 5.1. The consultant may appoint and remove trustees in their absolute discretion and without giving reasons. That's clause 6.2. The trustees must receive advice from the consultant under clause 8.1 on pretty much anything to do with the trust fund. And the trustee appoints his or her own replacement under clause 7.1. It's a self-perpetuating office. We submit that, along with the Court of Appeals, we respectfully adopt the Court of Appeals submission that, having regard to that wide range of powers the trustee, the consultant is given, it can't be just seen as a merely advisory role. Turning then to clause 18.1, the trustee may vary any or all provisions of the deed, a very wide power of variation for the trustees, not the usual may vary powers of management and administration. This is, to put it colloquially, an all-singing, all-dancing variation clause. And finally, clause 19.1 is of some importance. No beneficiary or third party has any claim, right or entitlement to call for accounts, obtain any information about the trust fund or income, or any information in relation to the trusts and powers. That is a wider power, my lord and my ladies, my lords and my lady, than that in the Tam case. It's the next thing I was planning to do.
Well, if we're leaving the Ararangi trustee, bearing in mind it is now 4 o'clock, would that be a convenient moment for you?
I think it would, my lord. What I will do...
We get the impression that you are motoring very effectively through your submissions and are unlikely to want to continue until 12:30 tomorrow.
I suspect that will be the case, but I am, of course, in the board's hands in case I...
Well, you have got until 12:30, but it may well be that you won't take that time. But it's a matter for you, Mr. Hikaka.
Thank you, my Lord. I certainly do not wish to take any more time than I need, but nor do I wish to.
You haven't wasted any time at all so far. Thank you. Well, then, the board will now rise until 10:30 tomorrow.